Wasting money on cures. Forgot how to fix myself. They say that time is free. Then why is it so precious? Oh, I'll say memories in my head, like Polaroids on walls. They remind you to look ahead. Time is running out. Time is running out. Lately I've lost my track. I've sailed the deeper seas, hoping to find something to bring back better times. Oh, I'll say memories in my head, like Polaroids on walls. They remind you to look ahead. But time is running out. 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 Time is running. Time is running out. But time is running out. What if my best days are over? They can't be over. They can't be over now. Time is running out. What if my best days are over? They can't be over now. Time is running out. Time is running out. Time is running out.
Good evening, everybody. It's John here from Tutor to You, welcoming you along to this, the first A-level law live stream of this academic year. A very warm welcome to any of you who are joining us live, and a equally warm welcome to anybody who is joining us on replay. Now listen, if you've not been to one of our Tutor to You live streams before, the format is this. We've got 30 minutes of fast-paced activities, which I'll come to in a few moments. At the end, I'll press the finish button, and this will have all been recorded, so you can look at, watch this again and go over some of the questions again. And the PowerPoint that we're going to use tonight to deliver some of the questions, that will be available for you to download as well, should you wish to do so. So that is the process. Now, I'm not a law expert. I am joined by people who do know what they're talking about. I've got Emily on the very left of the screen. I've got Liz in the middle of the screen. Good evening to both of you.
Hello.
So we have got a series of fast-paced, quick activities that generally don't require much interaction in terms of the size of a response. So one or two of them are longer questions, but most of them just require 1 letter or 2 letters. We would love it if you are watching this live to respond to the questions directly by putting them into the chat window on YouTube. Brilliant. I think that's all of the introductions out of the way. Shall we get started?
Let's do it.
Sounds good. Okay, so we've got a range of activities this evening for you, which are focusing upon Actus Reus. Actus Reus, for many of you, will be the first topic that you look at within criminal law, and that's because it's, along with mens rea, the real bread and butter of criminal law, and it's absolutely fundamental that you have your understanding of Actus Reus down so that you can then build upon that within the context of the different offences. So first activity, we're going to do some multiple choice questions. The first one is nice and easy. Hopefully you know this. So the first one is, what is the translation of Actus Reus? So if you have joined us, if you're joining us live, pop the answers in the chat. You should have a little text box somewhere on your screen which you can click into and engage in the chat, and you can pop in the letter that you think corresponds with the correct answer. Some of those are starting to come through, which is great, and we can reveal the answer as hopefully you know is C. So Actus Reus means guilty act, mens rea means guilty mind, and the general principle of criminal law is that you need both of those at the same time in order to be guilty of an offence. Now, the thing I always say to students at the very start of doing that A-level law course is, whatever I say to you, there are always exceptions. So we know there are exceptions. Some offences don't require mens rea, such as strict liability. Okay, so we'll move on to the next question. So when must the defendant have committed the actus reus of an offence? Is it within a 24-hour window of the guilty mind, before, after, or whilst they had the guilty mind? I think I probably have just told you the answer to this, but we'll ignore that for a minute. So if you pop the letter into the chat that you think is correct, we can reveal that the answer is D, whilst they also had the guilty mind. So this relates to a principle of mens rea but it's actually both coincidence of actus reus and mens rea, also known as the contemporaneity rule. You are supposed to have, the act is not guilty unless the mind is also. So actus reus and mens rea combined are those fundamentals of criminal law. So we'll move on to the next question. The next question is, offences where the actus reus requires proof of causation are called what? So again, if you could pop the letter of the correct answer into the chat. So actus reus of an offence will generally indicate two different type of guilty acts, and for one of those types of actus reus you have to prove causation. And the answer is, Tyrone's got it there, well done. The answer is A. So result crimes which require proof of a particular result. So the actus reus describes the causing of the result as the guilty act. It might not describe how you have to have caused that result, but if you have done any act that causes that result, you're liable. So that could be murder, GBH, ABH. So, the actus reus of those offences doesn't say you have to have caused death by, stabbing, shooting, beating. For example, for murder, it just says if you've caused death, then that's the actus reus. So it's not for all criminal offences that you need to prove causation. Often that can be an area where students get things a little bit wrong in an exam. There's a conduct crime, but they go through causation. You only need to go through causation for result crimes. So move on to the next question. So which of the following is not a general principle of actus reus? It's really, really important to have a good understanding of this is a general principle, and these principles of law are the exception. So an actus reus has got some general principles which it has to adhere to. So again, pop the correct answer in the chat if you think you've got it, and the correct answer is A. So it's not a general principle of actus reus that offences can be committed by omission, and omission being a failure to act. Okay, so generally, if we work from the bottom up here, the actus reus must be a positive action. You must commit an offence by committing an act. So generally, you can't commit an offence by omission. There are some exceptions. There are some circumstances where you can, and also C, it must be a voluntary act. Okay, if we move on to the next one. So going back again to thinking about which crimes are result crimes, which crimes are conduct crimes. So which of the following is not a result crime? So for which offence listed here would you not go through causation? Okay, this is kind of just an example. It's not necessarily something's on the spec, but we can reveal that the answer is... Some of them have got it, yeah, B, well done. So speeding is an example of a conduct crime. If you speed, if you just speed, obviously illegal, don't do it. But if you just speed and it doesn't cause any result, if somebody speeds down the motorway at 2:00 in the morning and doesn't see another car, they haven't necessarily caused a particular result. There's no specific harm caused, so you don't need to go through causation. It's the act, it's the conduct. So it's known as a conduct crime. It's the conduct, the action of doing the speeding that is being criminalised. And generally, conduct crimes are criminalised because of the risk which is associated with that action. Okay, well done. We had quite a few good answers there. So first activity done. Our next activity is true or false. So what you need to do is read the statement. You can just put T or F in the comments. So the actus reus of all criminal offences will be defined within a statute. So pop that into the chat. Is that a true statement? T for true, F for false. So a statute is an act of Parliament. It's our written formal legislation by Parliament, our legislature. Yeah, well done. We've got Monty, Hannah, Tyrone have all said it is false. So the definitions of criminal offences can come from statutes. So, theft, Section 1 of the Theft Act 1968 gives us our nice definition of theft. But we've also got some offences like murder where it's not written down in a statute, which is often a surprise to law students because you think, that's the most serious offence you can commit against another person. But those definitions are developed by the common law, so via our appellate courts. Okay, next statement. All offences have one element of actus reus. Is this true or is this false? So again, pop into the chat a T or an F as to whether you think that's true or you think that that's false. Okay, again, well done. Some familiar names here, so obviously are very good with your actus reus. This answer is false. So offences can have multiple elements of actus reus and mens rea. Theft is our prime example. So theft, if you haven't got onto it yet, there are 3 elements of actus reus. You have to appropriate property belonging to another, but there's 2 elements of mens rea. So, often offences might have more than one element of actus reus and mens rea that need to be proven. Okay, our next statement. So the actus reus of an offence may be the causing of a result or a particular type of conduct or behaviour. So again, and I've kind of given this away, I need to stop doing that. But T or F in the chat, and we can reveal that the answer to this one is true. So as I said, you either have conduct crimes which criminalise a behaviour and result crimes which criminalise the causing of a particular result rather than it specifically how you have caused it. Okay, so next statement. So there are some exceptions where you can commit the actus reus of an offence by omission. So T or F. Are there exceptions? Are there circumstances where you can commit an offence by omission? Okay, so Connor said false. Any more thoughts? Is that true or false? So are there some circumstances where you can commit an offence by omission? Yes, and Monty and Tyrone have got that there. The answer is true. So generally, you can't commit an offence by omission. And actually, if the definition of the actus reus of an offence says an act, then you can't commit it by omission. So, for example, unlawful acts manslaughter, the first thing you have to prove is an unlawful act, and it was confirmed in the case of Lau. That means that it cannot be committed by omission. However, if the definition of the actus reus doesn't specify an act, it is possible to commit an offence by omission if you're under a duty to act, and the law recognises a number of duty to acts. There is also circumstances where Parliament can specifically create an offence which criminalises an omission. So, for example, it is a statutory offence to fail to provide a specimen of breath at the roadside when requested. So, if somebody's been suspected of drink driving, they refuse to provide that specimen of breath to determine the level of alcohol in their blood, that omission, that failure, that refusal is specifically a criminal offence. Okay, so we shall move on. The law of causation has been wholly developed by the common law. So this is a bit of a trickier one, but pop your answer into the chat. Do you think that's true? Do you think that's false? Has the law of causation wholly been developed by the common law? See what people think. So we can reveal that the answer is true. So when you look at causation, there's really detailed rules on factual causation, legal causation, the novice actus interveniens. You will look at cases. So a really substantial amount of our law is developed by the common law in the courts. And that's because the law needs to be flexible and agile. If you introduce really, really strict rules, strict statutory rules, very clever lawyers find ways to find loopholes and different ways of interpretation. So complex area of law, and causation is really, really complex. Morally, ethically, legally, you will often find that these areas of law are developed by the common law. Okay, and next, so this is one of my favourites. I do this often with students. Is word association. So you've got 60 seconds to find words or phrases to do with Actus Reus associated with the word below, starting with the letters from that word. So what I want you to pop in the chat is an Actus Reus phrase that begins with C, A, U, etc. So we will start the timer. Off we go. So pop them into the chat. I'll be very impressed if somebody can think of a relevant phrase to Actus Reus that begins with each of these letters. I think U's pretty tough. There's 2 A's, even though A would be an obvious one. Yep, so Steve, causation. That one's a given. But thank you, Monty. So A, U, S, act. Yeah, act. Actus Reus. Think about U and S. S is a pretty tricky one. But yeah, see if you can think about I's quite easy, I think. O's quite easy. N. Okay. Last few seconds. Fab. So we shall reveal the suggested answers here. So C, conduct crimes, Actus Reus, unlawful act, state of affairs, offences. Tyrone's put substantial for S, that would be good. Actual, so factual causation, sometimes known as actual causation. T, the thin skull rule, which is relevant to legal. You've got intervening acts, omissions, and then your novice acts interveniens. So that was a bit of a tricky one. So well done. Okay, I'm going to hand you over to Emily, who is going to go through the remaining Actus Reus activities.
Thank you very much, Liz. So the next activity is called altered vowels. As you can see, each of the key phrases are going to have their vowels changed to an alternative vowel. Your job is to pop your answers in the chat and tell us which word is being presented on the screen with its changed vowels. So like Tutor to You, thank you, as just mentioned, it's going to be a quick fire one. So fingers at the ready. Let's see the first one. Okay, so the word is on the screen. As soon as you've figured it out, pop your answers in the chat. We are not going to have long per round on this one. Off you go. What do you think this word is? It's been mentioned a few times already by Liz. Key one that you would need to mention for Actus Reus if it was relevant to a scenario question. Remember, those vowels have been changed. Fantastic. Well done. We've got a couple of correct answers straight away. Let's reveal the answer. Omission. Fantastic. And an omission, hopefully you've been paying attention, is a failure to act. Now, as Liz mentioned earlier, an omission, which is a failure to act, does not usually satisfy the Actus Reus of a crime, but it can do if there is a duty to act and somebody fails to do that. Bear that in mind for our last challenge. We are going to do a 30-second challenge at the end of this, where I'm going to ask you directly about when the Actus Reus could be satisfied via an omission because a duty is owed. Let's move on to the next one. Okay, same again. As soon as you guess the answer, pop your answer in the chat. So this is 3 separate words. And remember, those vowels have been changed. This one seems a little bit harder for people. But Tilly's got it. Congratulations. State of affairs. Well done. Let's reveal that answer. Congratulations. So this is where the Actus Reus and the mens rea the mens rea is not required, and the Actus Reus doesn't even have to be done voluntarily by the defendant. Simply put, they only have to prove that the Actus Reus happened, not that the Actus Reus was done intentionally or voluntarily. For example, in the case of larceny. Okay, let's move on to the third one. Again, straight away pop your answers into the chat once you've realised what that key phrase is. Remembering that those vowels have been changed to alternatives. Let's see who's going to be first in this one. This one's 2 words. Very quick. Well done. Let's reveal the answer. And it is factual causation, of course. This is tested using the but-for test, where you ask, but for the defendant's actions, would the consequence have occurred? And that consequence may have been death, for example, if you were to be doing a murder question. Your key case that you would use to illustrate this would be R.V. White, which illustrates the principle of the but-for test. Fantastic. Let's move on to the next one. Oh, thank you for mentioning that key case there. Well done. Okay, a little bit harder, simply because it's a longer term. There are 2 words. Again, pop your answer in the chat when you think you know the answer. Let's see who gets it the quickest. Yes, tutor to you, you are right. We're all getting very quick at this. Let's see who gets it the fastest. Oh, 2 people, I think, went at almost the exact same time. Yes, let's reveal the answer. You are both correct. Reasonable foreseeability. Let's move straight on to the next one. Okay, this is our last one. This is 3 words, and I feel like this is the hardest one, simply because it is not English. That might be a bit of a giveaway. Let's see who's first. 3 words, not English. But it is still a very key, important key term for our Actus Reus. And there we go. We've got a few people with the correct answer. Congratulations. It is, in fact, Novus Actus Interveniens, or however you want to pronounce it. I've heard it pronounced in many, many different ways. So this is the idea that something can break the chain of causation, which is relevant to proving the Actus Reus of an offence. There are several things that can break the chain of causation, including things like the victim's own act, a third party. You do have to consider whether the act of a third party, for instance, is bad enough for it to be considered an entirely separate event and therefore able to break the chain of causation. If it's the victim's own act that you are arguing is a new intervening act, you have to consider whether the victim's own act was reasonably foreseeable. If their behaviour was reasonable, then it won't break the chain of causation. Something, again, to bear in mind for another challenge that we are about to do. Let's move on. Okay, this is our 60-second challenge. You have 60 seconds to match the Novus Actus Interveniens to the relevant test or the impact on the chain of causation. So to put it simply, you are matching the letters on the left with the numbers on the right. And to make it easier, I simply need you to put the number and the letter that you pair together. You don't need to write out any words. So for example, thank you. So for example, you might write A1. I hope that makes sense. You are going to have a full minute to do this. I'm not going to talk too much during this time, so I don't put you off, because you do need to concentrate. So I might give you some hints and tips, but let's get started. Off you go with your 60-second challenge. And remember, you are only putting the letter and the number in the chat. You don't have to type any words. That should make it quicker for you. All right, that's 30 seconds of your time gone. You've got about 30 seconds left. Bear in mind what I've mentioned earlier when we were going through the previous activity about the actions of the victim and the third party. Your final 10 seconds. 5. Okay, pop your answers in the chat when you are ready. Again, remember, you just need to put the letter and the number. You don't need to type any words. So we've got some answers coming through now. Let's see what we've got. Okay, yes, fantastic. So A1, C5, B4, okay. Any other answers? Seems like this was a difficult one for people to do in the 60 seconds. Don't feel as though you have to put every single one in. If you've only got a couple of answers, that is absolutely fine. Nothing to worry about. Okay. Fantastic. A few more coming through now. Okay, let's reveal the answers. Well done, everyone. So, for A, you should have had 4. third-party intervention can be considered sufficiently independent and unforeseeable from the original defendant's action. So, for example, somebody is, say, in a fight, they get injured, they are taken to hospital via an ambulance. On the way, there is a car crash that is caused by some entirely separate third party. That is sufficiently independent and totally unforeseeable from the original defendant's action of, say, a punch to the head. B, negligent medical treatment needs to be so overwhelmingly bad for it to break the chain of causation. Simply, a minor negligence is not going to be classed as so overwhelmingly bad that it breaks the chain of causation. Your key cases here would be cases like Jordan or Smith. Some teachers might teach you Cheshire, for example. Any of those would be appropriate. Moving on to C, the actions of the victim. If they are reasonably foreseeable, they do not break the chain of causation. For example, if somebody were to run away and fall over as a result of running away from a defendant who's trying to attack them and harm them, that would be reasonably foreseeable. So them falling over and getting injured would not break the chain of causation. Your two key cases here would be Roberts and Williams. In the case of Roberts, there was no break in the chain of causation because the victim's actions were reasonable. However, in the case of Williams, the victim's actions were not considered reasonable and so did break the chain of causation. Moving on to neglect of the victim. This does not break the chain of causation. Similarly to E, the conditions of the victim doesn't break the chain of causation. Conditions of the victim referring, of course, to the thin skull rule, which your key case is Blau for. Okay. We are moving on now to our final challenge. This is a 30-second challenge. You will have 30 seconds to simply answer a question on the screen. There are multiple answers, so I'm not asking for just one answer. Feel free to type them all out and wait until the last second to press enter and put them all in. Alternatively, you can be putting them in as the 30 seconds are going. I don't have a preference either way. So, your question is on the screen. I'll read it out before the timer starts. In what situations does the law impose a duty to act, making an omission, a failure to act, capable of forming the actus reus of a crime? So I'm asking you that, but then also, if you can, a stretch and challenge question. So tell me first of all, what situations a duty is required, a duty exists where a defendant is required to act and therefore failing to act would satisfy the actus reus. But also, if you can do that, tell me which cases illustrate each of those duties. Okay, let's get started. You have 30 seconds. Pop your answers in the chat as soon as you're ready. Alternatively, you're welcome to wait until the end and type all of your answers in and then press enter at the very last second. Congratulations, Brogan. Well done. That's our first answer. Okay, I'm just going to give everybody a few more moments to pop their answers into the chat in case they've been typing in a few. All right, we've got quite a few answers coming through now. Yeah, Adamako, Stone and Dobinson, good answers. Contractual duty for Pitwood, yeah, brilliant. Okay, so we have quite a few. There are several key ones, but there are tons and tons and tons. We simply don't have time to go through every situation where a duty exists. But some key ones that you will have likely been taught would be contractual duty. Your key case there would be Pitwood. A duty to avert a danger of your own making. You might have been taught R.V. Miller for that one. A public duty, R.V. Dytham. Duty due to a special relationship, such as husband and wife or parent and child. For that one, you could use Gibbons and Proctor. A voluntary assumption of responsibility for Stone and Dobinson. But people have mentioned a few others. So yes, R.V. Winter is a good example. Adam Mako. You could have you could have duties in contractual cases like employment. An employer owes a duty of care to their employees. Manufacturers owe a duty of care to consumers. There are tons and tons. Liz, are there any others that you would like to mention that you make a point of making sure that your students are aware of with the key
No, I think you've covered all the key ones there.
Okay, fantastic. All right, we've still got some answers coming through, so well done, everyone. That that concludes our final challenge. Well done very much for getting involved. You've all done a fantastic job there, and it's clear that your knowledge of Actus Reus is wonderful. So very, very well done to you
Very,
all.
very impressive as far as I'm concerned. Some wonderful answers. And listen, thank you to everybody who took part in the activity tonight and gave us some answers. It always helps us to know what you're aware of and what you're not aware of. So brilliant stuff from everybody who took part. Of course, a massive thank you to Emily and Liz for delivering those questions tonight. As I said right back at the beginning, as soon as I press the finish button in a few moments' time, this presentation should be available for you to download should you want to go through the questions again. And this has all been recorded, so you can always look through some of those questions at your leisure at a different time. Now, we're back next Thursday at exactly the same time, 6 o'clock. We're talking about mens rea next, mens res next week. So forgive me for my pronunciation there. Do join us if you found tonight useful. And if you have found tonight useful, please do give us a thumbs up in YouTube. That helps us get our message across there too. Until another time, thank you again, and goodbye, everybody.
Thank you. Well done.